Today I'm talking about demand letters and what is a demand letter in the context of a personal injury case. So the purpose of a demand is to initiate settlement negotiations. It's an opportunity for your attorney to set out what they're seeking on your behalf for the case, but really it's also an invitation for the insurance company to either pay that demand or respond with a counteroffer. So it could be a tool for starting negotiations. It also provides a clear summary of the case, so it can be used by you and your attorney to identify to the insurance company or their lawyers critical or important aspects of the case and your position on those. It's also an opportunity to put forward evidence that supports your claim and to highlight some of the strengths of your case and what you intend to prove if the case doesn't settle. Part of the demand, obviously, is the amounts for compensation. Oftentimes it will have a number, sometimes it's broken down with a justification in terms of how that number was calculated by your attorney. And very often demands have a time limit to them. Sometimes they'll remain open for a certain period of time, 30 days, 60 days. And that's, again, a tool to help facilitate a timely resolution of your case. Many lawyers have different styles on how they author a demand letter, but generally speaking, most demand letters share some common key components. Typically, they'll have an introduction and a summary of the events and incident and what occurred. There will often be a liability section describing the fault or blame of the party. There's generally a section describing the nature of the injuries and the medical treatment obtained to date. And then very often there will be sections or components describing financial losses or economic losses such as medical bills, income loss, wage loss, out-of-pocket expenses, and then also a summary of your pain and suffering or your non-economic losses. Demand letters are also typically part of a package that includes the supporting evidence, oftentimes medical records, police reports, photographs, property damage documents, those sorts of things to support what's being claimed in the demand. Demand letters also state the total compensation that your lawyer is seeking on your behalf. And finally, they almost always have a deadline for response. They usually are not open indefinitely, but will have a deadline so that it encourages the insurance company to take it seriously and respond. Some of the reasons why a demand letter can be important: it sets the tone. It's upfront. It tells the insurance company exactly what you're looking for and the reasons why. It also tells them how much money you're looking for. So it helps them establish what the case is all about, but also what the claimant is seeking in terms of a recovery. Secondly, it can initiate settlement discussions and help resolve a case. And in doing so, it can avoid lengthy and costly litigation, filing suit, going to court, taking depositions, hiring experts. So a demand can have some value there where it can resolve a case sooner as opposed to going through the full litigation process. And lastly, it establishes a written record of the demand being made, in fact. And sometimes that can be important, particularly in situations where the insurance limits might not be sufficient. It could be important later that your lawyer demanded to settle the claim within those limits. The written record is also important in some circumstances where a claim later ends up exceeding the policy limits. So I'm asked sometimes by other attorneys whether or not they should write a demand letter. Sometimes lawyers in our office, sometimes lawyers in other offices. My view generally is at some point a demand should be sent out, whether that's pre-suit or in litigation. But at some point you should tell the insurance company on the other side or the defense lawyer clearly what you're seeking in the case. Because otherwise, it'll be left to the insurance company to guess and to evaluate the case on their own without any guidance from you, any sort of markers. If they're left on their own to do it, they're generally going to undervalue the case, in my experience. And then it's sometimes difficult to change assessments, to change opinions. And your work becomes more difficult because all along the insurance company was assessing the case based on their own value without your input. And if you surprise them for the first time with a demand in the later stages of litigation, sometimes it could be counterproductive and harder to get that resolution. When you have sufficient information to assess the value of a case, it could be a good time to do a demand. Demands can also be made over the phone. They can be made verbally. They can be made at settlement conferences. And most attorneys prefer to put it in writing or at least memorialize it in writing after the fact. So what do I mean by that? Medical records, wage loss records, bills were all sent over to the insurance adjuster, and then you had a phone call with them 2-3 weeks later once they've had a chance to review it, and you make a demand over the phone and you say, okay, now you had a chance to review it. On behalf of my client, we're demanding X. Best practices would be you hang up the phone, you follow up with a letter saying further to our telephone call, this will confirm that we've made a demand for X dollars. It expires on this date. We look forward to hearing from you. Generally, you do want to record it in writing, even if initially it's expressed verbally. I wouldn't suggest doing demands prematurely or off the cuff or without sufficient information. If you're still not sure what the total damages are going to be or likely to be, then obviously it's important to first let it play out, the medical treatment, the prognosis, and the outcome and the impacts it's having. But once that information becomes available, in most circumstances, I would recommend a demand.